Hello everyone, welcome back to the channel. A bit of a break from the Johnny Depp trial coverage because the trial has actually been on a 1-week break, which is about to end. But over the weekend, I was sent Meghan Markle's motion to dismiss Samantha Markle's defamation case against her in Florida. So I thought we could quickly go through it and see what Meghan's arguments are for getting this case dismissed. I have covered Samantha's complaint in quite some detail, and these two videos will be linked in the description box. Part 1 is more concerned with the complaint itself. We go through it. But part 2 concerned issues that I saw and weaknesses in Samantha's case that could potentially lead to getting it dismissed, which a lot of these issues actually come up. So the Duchess of Sussex Meghan sued as Meghan Markle. So that's why we see here that she is responding as Meghan Markle because that's how she was sued. Respectfully moves to dismiss the plaintiff's complaint for failure to state a claim. So basically there is no case. So I'm not going to go through this in detail because the point of this is to give you all a quick summary. But essentially the main points that have been put forth by Meghan's team is that as far as the email is concerned that she sent to Jason Kanoff in December of 2018, the statute of limitations has run out. If you haven't watched my 2 videos on this case, which again I urge you to because it gives you all the context and the background, a statute of limitations is basically the time period that you can sue someone for something. In the case of Florida, for defamation law, it's 2 years. Now, the general stance, the legal standard, is that the statute of limitations starts on the date of publication, regardless of when the plaintiff discovers the publication. But in some instances, and I have spoken about this in part 2, I believe, of this case, the statute starts when the plaintiff became aware. And this usually only applies when publication was done in private. So for example, in this instance, Meghan's email to Jason Kanoff was sent in December of 2018 to Jason Kanoff, and Samantha had no way of knowing. And so some jurisdictions have leeway where the statute of limitations would start when Samantha became aware of the email, which I would say is November 2021, because that's when it was leaked in relation to Meghan Markle and the appeal case brought by Associated Newspapers. But as you can see here in Florida, the statute begins to run at the time of publication and not from when the defamation is or reasonably should have been discovered. In other words, unlike some other jurisdictions, there is no discovery rule for defamation cases in Florida. So that's why in my video, I know that there are jurisdictions where there is a discovery rule, but Florida does not observe that discovery rule. It doesn't recognize it. And since this case was filed by Samantha in March of 2022, this year, it was way past the 2-year statute of limitations, specifically in regards to Meghan's email to Jason Kanoff. Meghan's team also talks about how getting these sorts of cases dismissed early are particularly appropriate in defamation cases. Now, I will summarize this and say that this is particularly in relation to the chilling effect, and I'm quoting here, that defamation cases can have on freedom of speech. And so courts must take particular care with not allowing such infringements on freedom of speech by dismissing such cases early if there is no merit. The third point is that Meghan did not publish any of the statements in Finding Freedom, and this is something that came up in part 2 of my coverage of this case. I was worried and concerned that Samantha is suing the wrong people in this instance, or the wrong person in this instance, or at least made a mistake by not joining the authors of the book. Because at the end of the day, they wrote the book and they published it. And if you'll cast your mind back to part 1 of this coverage of this case, I laid out the elements of defamation. And so Samantha must prove that Meghan Markle authored these statements, but not only authored them, published them, which with regards to the statements contained within Finding Freedom, it is clear that Meghan was not the author and did not publish the book. Now, a central element of this case is that what was contained in Meghan's email to Jason Kanoff can directly be linked to what was eventually published in Finding Freedom. And this was mentioned in this motion to dismiss, but they disagree, and they go through in quite a bit of detail to demonstrate to the court that most of what Meghan said did not eventually make it to Finding Freedom. And they also focus on the fact that she sent this to Jason Knopf. She didn't send it directly to the authors. And so Samantha would have issues in proving that Jason Knopf then sent that very email to the authors. And so it's arguable that they, one, may never have received that email directly authored by Meghan and have relied on media outlets and Samantha's interviews herself, which she's been given since 2016, to write that chapter 12. Which was dedicated to Samantha, essentially. So they go through numerous case law to demonstrate to the court that Meghan didn't have any control over publication, whether directly or indirectly. So what they're saying here is whatever Meghan wrote in her email, she can't be held responsible for the publication of Finding Freedom and the statements contained within the book because they were made by other people, and it's, according to them, very easy to prove that their sources were not Meghan Markle. They stated that the courts in this district have unequivocally rejected the proposition that a defendant can be liable for republication by a third party over whom the defendant has no control, solely because such a republication might have been reasonably foreseeable. So in other words, just because, they're going along like, let's pretend that it was reasonably foreseeable that this email would leak, which from their arguments, I can tell that they don't accept that. But playing devil's advocate, they went, let's pretend it was reasonably foreseeable. That still doesn't in any way mean that Meghan is responsible for republication by a third party, in this instance being the authors of Finding Freedom. And then they go on to list case law of a similar nature to demonstrate that republication by a third party should not, according to Florida law, make the original author liable. Because they, for example, may have never intended for anything to go public. And so the third party in Florida, the person who actually did the publishing, is to be held responsible for defamation. Next, they go into detail to demonstrate that there is no overlap between the email to Jason Knopf and Finding Freedom. So this is what I talked about earlier. Most of what was contained in Meghan's email didn't even make it to the book. And so you cannot say, they're arguing, that Meghan's email and Meghan herself was the source of all the allegedly defamatory statements that made it in the book. For example, Meghan said that Samantha was a high school dropout in her email, but the book never claims that Samantha dropped out of high school. The book also never asserts that Samantha changed her last name back to Markle, and it never addresses her children and who fathered them, or whether she even lost custody of them. So even if Samantha could satisfy the publication requirement, which they say she can't, so basically Meghan's not responsible for Finding Freedom, there is no basis for alleging that the authors used the allegedly defamatory information in Finding Freedom. Now, the sole possible exception, the only weakness they identified, is the statement in Meghan's email that Samantha started brokering press deals for her father. But they say that the allegations in the book are far more specific than mere brokering. In particular, Finding Freedom describes a plot by an individual named Jeff Rayner to go around town and to photograph Thomas Markle, in the internet cafe, and all those, getting measured for the suit, all those pre-wedding paparazzi shots that were staged. And they're arguing that this was all public knowledge. It was leaked. It was available in the media for the authors to use as their sources to write about it in the book. So whatever Meghan said in her email, brokering press deals, was just the tip of the iceberg. The authors went into a lot more detail from allegedly other sources. And hence, Meghan can't be responsible for what they said about Samantha brokering press deals in Finding Freedom. Now, they also include here in this footnote that Samantha actually doesn't deny arranging staged paparazzi photos of Thomas Markle. And so it's true. And by its very definition, the truth is never defamatory. The reverse applies as well. There are many statements that appeared in the book that were not discussed in the email at all. So for example, the 2018 email said nothing about photos, let alone that the plaintiff would have sold them to make money. The email, Meghan's email, did not assert that Samantha reached out to the Sun or that she was paid handsomely by it, although I do remember her email saying that she started a career of spinning lies, to make money out of her sister, essentially. The email didn't mention Meghan's first wedding. I remember failing to see that connection as well when we went through both documents to see if things lined up. And it also didn't mention any conversations with Thomas Markle about Samantha. So in summary, they say, for the vast majority of the statements at issue, there is simply no connection between Meghan's December 2018 email and the book Finding Freedom. Now, on to the Oprah Winfrey statements that were made. This is where I told you guys that whatever she said on the Oprah interview can arguably be demonstrated to be her opinion, her subjective point of view on the nature of the relationship between her and her siblings. We cannot objectively prove that Meghan didn't see herself as an only child. It was maybe in her head, in her own opinion, her own viewpoint, that she grew up an only child, despite having half siblings. We can't objectively prove that Meghan didn't have a close relationship with her siblings, because to her, in her head, she could have seen it as not a close relationship. It's her opinion. So this has appeared, it has manifested in Meghan's motion to dismiss. In terms of the number of years that Meghan last saw Samantha, now in the interview, I believe she said, 18, 19 years ago, 20 years ago, I don't know. But they're saying, look, when it comes to defamation, what matters is that the gist is true. So substantially true means the gist of the statement is true. It doesn't have to be 100% absolutely true. What they're saying is, fine, the last time Samantha saw Meghan in person was during Samantha's graduation ceremony in 2008, which was 13 years before the Oprah interview. And so it's semantics, 18, 13, who cares? The gist is that she hadn't seen or spoken to her sister in person for a very long time. And so her statement stands to be true, or at least substantially true, and is therefore not defamatory. And finally, the comment Meghan made that Samantha started going by Markle just when Meghan met Harry and her stardom, truly commenced. Meghan's team argues that that is substantially true because they have proof that up until essentially 2016 even, Samantha still went by Samantha Rasmussen, which was her married name. Now, she did divorce her ex-husband in 2003, the ex-husband who carried the surname Rasmussen, but she kept using it. And there is evidence that at least until September 2016, just 2 months before Meghan's relationship was widely reported, Samantha was still going by that surname. Then they say 12 years after Samantha's divorce from her husband and mere months before Meghan started dating Prince Harry, she was still going by Rasmussen and Grant, but not by Markle. It follows that any statements to the effect that Samantha changed her name are substantially true. I don't believe they adequately addressed Meghan's comment that Samantha did this for clout, which is what makes it defamatory, that she is stooped so low that she changed her name back to Samantha Markle to trade off that surname because of her sister's association with Prince Harry. Now, is that statement by itself enough to warrant a defamation claim? It's subjective. I think from a lawyer's point of view, defamation cases are incredibly complex, expensive, stressful. And so is it worth it to pursue something so hard and to potentially lose and have to cover all of Meghan's legal costs simply because her sister said, well, she changed her name when I became famous? It's up to Samantha to answer that question. And if she wants to fight this motion to dismiss tooth and nail and really push. I'm kind of getting ahead of myself. I want to leave that for the closing. But to end off, Meghan is seeking attorney's fees and costs. So she wants Samantha to pay for all the costs incurred in relation to this lawsuit so far, specifically referencing Florida's anti-SLAPP statute. Now, anti-SLAPP laws exist to protect freedom of speech, and it exists to protect threats of defamation, to limit people's freedom of speech and to silence people. I, for one, am an advocate of anti-SLAPP laws because there are some nasty people out there who will sue you or will attempt to sue you simply because they don't like you spreading the truth, simply because they don't like you airing out their antics, exposing them, because they operate in lies. But in this instance, I think it's crystal clear that that's not Samantha's objective, at least to me as a bystander and as an observer. I think what she's trying to do is get the truth out. However, Meghan's team is using the anti-SLAPP laws to say that, well, you know what? She's wasted our time and money to limit or suppress Meghan's exercise of her First Amendment, so her freedom of speech. Specifically, the anti-SLAPP statutes prohibit the filing of a lawsuit that is without merit, so there's no basis for the lawsuit, and arises out of the defendant's exercise of the constitutional right of freedom of speech in connection with a public issue. So basically, they're arguing that Meghan made her statements, first of all, as part of her, freedom of speech, her exercise of that right. But also, she made it in connection with a television program or a news report, which is the Oprah interview. And so it meets a specific criteria of anti-SLAPP laws, which is free speech in connection with a public issue. So Meghan is commenting on a public issue being, I suppose, Megxit and her life in the public lens, and perhaps even the racism, issues of public concern, essentially. And therefore, the anti-SLAPP laws kick in. So that's about it for this complaint. My thoughts are this. I saw this coming. If you watch part 2, you will see that I raised numerous concerns that ended up, like I said, manifesting here in Meghan's motion to dismiss. Can Samantha prevail and push for this further? I think it's pretty weak at this point, her chances of pursuing this further, specifically because of the statute of limitations that applies to the email. Florida does not observe the discovery rule. The statute of limitations begins upon publication. So 2022 is almost 4 years after 2018 and way out of the 2-year statute of limitation period. In terms of the statements published in Finding Freedom, again, something I talked about in part 2, I really think she's going to have a lot of trouble with going ahead with those statements in particular, because they were authored by completely separate people, by third parties who also then went ahead to publish it. And it is reasonable to argue from, again, an objective standpoint to a court that Meghan had no control over the publication. Whether that's true, we don't know. We need evidence that Meghan, in fact, did control when that book would be published, and even if it would be published at all. It is possible. I don't think it's beyond the realm of possibility that Meghan did indeed have that control. But at this point, it's just speculation. Samantha needs cold, hard evidence to prove said control. But then there's also this other separate issue of a weak link between the emails and what actually eventually ended up getting published. There is plenty of information out there about Samantha. So it is actually really viable that the authors used news outlets and external sources of information to write the book. It's not like Samantha wasn't a public figure, really. For the purposes of this case, she definitely meets the criteria of a public figure because she has put herself out there. Not that there's anything wrong with that. In fact, I think she should use her public profile right now to combat her sister's lies rather than trying to go ahead with this lawsuit. So maybe it's worth letting it go away and, fighting for the truth in her own way, where it doesn't involve hundreds of thousands of dollars that she probably or most likely doesn't have. Meghan's got the money to fight this. So she is definitely at a disadvantage when it comes to financial resources available to fight this and to really push for this. I have to say, and this is just my professional opinion, there are other lawyers out there who could have a completely different opinion to mine. There could be other people out there, the audience, that completely disagree with what I think, and that's fine. But based on the information that was available to me a few months ago, before this was even published, this motion to dismiss, I had grave concerns for Samantha's prospects of success. And, if there was anyone to sue in this instance, I suppose it would have been the authors. Now, theoretically, she could drop this case on the grounds of, I'm going after the wrong person, I guess. And she could go after the authors. Nothing's going to stop her from doing that. Getting this case thrown out doesn't necessarily mean she doesn't have a claim to defamation. but she's just gonna have to sue different people. That's it for this video. I hope you found it informative. Please don't misinterpret this as me siding with Meghan. I side with the law in terms of if the arguments are legally sound, if they are, by the book, they abide by case law, they abide by legislation, I'm not going to argue against it. The arguments that Meghan's team put forth are quite strong, I have to say, with a few weaknesses here and there. But would those weaknesses be enough to survive and push the case all the way to trial? Because at the end of the day, the overarching objective of courts is the efficient and fair administration of justice. Efficiency means with as little time and resources as possible. And they push for out-of-court settlements. Courts encourage that. Courts encourage alternative dispute resolution, specifically for these reasons, to make sure that time and money are not wasted. I don't think this case is strong enough to survive the dismissal. If I'm wrong, that's good, but don't forget that it will then go to trial, where it will most likely be a jury trial, because this is the States. Here in Australia, we don't really get jury trials in civil cases. But if Samantha then goes on to lose anyway, she's only going to have to pay not only all of her legal costs, but all of Meghan's. So she really has to think about it. I think at this point, her lawyers would be wise to advise her. And, at the end of the day, it's up to her. But it is, you have to weigh things up and figure out whether it's worth it. Because like I said, she's a public figure. All she has to do is call Dan Wooten and give another interview. Put your side out. Combat the lies with the truth, but not necessarily by using the justice system. The justice system fails many people. But with today's resources like social media, YouTube, you can easily use these tools to get the truth out there. Let me know what you all think. I'm interested to see what happens and whether this gets dismissed. My gut instinct is that it will. But again, it depends on how Samantha's lawyers come back at this and argue against Meghan's motion to dismiss. All right, until then, thank you all so much for watching. And we're going to get back to coverage of the Johnny Depp trial because it will resume next week or this week by the time you see this video. And I am quite keen to get into Amber's cross-examination, so bring it on. All right, everyone, thanks, and I'll catch you later.